This is HOA outplayed. They wanted control. I am writing this down, I said, holding my phone up so she could see I was recording every word. Karen shouted that she would lien my house for tow fees if I made this difficult. Her face was red, her hand was shaking as she pointed at my guest's car, and the tow truck was already backing into position behind it. The wheel lift was sliding under the rear axle while she stood there filming me with her own phone, smirking like she had just won the lottery. I am an HVAC technician in Allentown, Pennsylvania, and I work nights, which means I sleep during the day and I have vendors, clients, and coworkers who sometimes need to visit. The Pheasant Run Design Review Association treats every single guest parking situation like a towable offense, and Karen Clark, the board secretary who controls all the paperwork, had decided today was the day she was going to make an example out of me. She said, "Keep talking, I love adding notes." That was her catchphrase, and I had heard it 3 times in the past month alone. Every time I tried to explain the rule or ask for clarification, she would pull out her little tablet, tap away, and repeat that line like it was supposed to intimidate me. The problem was that I had a guest pass on a lanyard hanging from my friend's rearview mirror, clearly visible through the windshield, and the pass was valid for today. My friend had driven up from Philadelphia to drop off a compressor part I needed for a commercial job, and I had followed the guest pass process exactly. I logged into the HOA portal, requested the pass 2 days in advance, printed it, filled in the date and vehicle info, and put it in the car before my friend even arrived. Karen did not care. She claimed the pass was not legitimate because the approval email I received did not match the physical pass format, which was insane because the HOA portal generates the passes automatically and I had no control over the design. I asked her to show me the rule that said the pass format had to match the email format, and she refused. She said the violation was already logged and the tow was already authorized, and if I wanted to dispute it, I could file a hearing request and wait 6 weeks for a response. 6 weeks. My friend's car would be in a tow yard racking up storage fees at $60 per day, and I would be stuck paying it because the HOA bylaws made the homeowner financially responsible for any guest violations. The stakes here were not just about one tow fee. I run a small HVAC business on the side, doing residential and light commercial work evenings and weekends, and my reputation depends on being available and reliable. If word got around that my HOA was towing client vehicles or vendor trucks out of my driveway, I would lose contracts. I had already lost one potential contract 2 months ago when a client showed up for an estimate and got a violation notice on their windshield within 15 minutes. The notice had no grace period, no warning, just a bright orange sticker that said the vehicle would be towed if not moved immediately. My client was furious, and they hired someone else. That cost me $4,000, and I could not afford to let it happen again. Karen knew this. She had made comments at board meetings about how homeowners who run businesses out of their homes should expect stricter enforcement because they create more traffic and parking congestion. Never mind that I do not operate a retail storefront or have customers coming and going all day. I work off-site most of the time, and when I do have someone visit, it is scheduled and temporary. But Karen did not care about facts. She cared about control, and she had figured out that parking enforcement was the easiest way to weaponize the HOA rules against anyone she did not like. The tow driver stepped out of the truck and walked over to me. He was a thick guy in a stained gray shirt chewing gum, and he glanced at Karen, then at me, then at the guest pass hanging in the windshield. He said, "Is that a valid pass?" I said yes, and I pulled up the approval email on my phone to show him. He squinted at the screen, then looked back at Karen. She said, "The pass is not valid, the homeowner is in violation, and I have authorization from the board to proceed with the tow." The driver shrugged and said, "I just need written authorization, and if she has it, I have to follow through." Karen pulled a folded paper out of her blazer pocket and handed it to the driver. I could not see what it said, but she announced loudly that it was a tow authorization form signed by the board president that morning. I asked to see it, and she refused. She said homeowners do not have the right to inspect board documents during enforcement actions, which was another lie, but the driver was already walking back to the truck. I stepped in front of him and said, "If you hook that car, I will file a complaint with the state towing board and the police for an illegal tow, because that guest pass is valid and you have no legal grounds to remove the vehicle." The driver stopped. He looked at Karen again and she said, You are not the first person I have corrected, and you will not be the last. That line hit me like a slap. It was not just arrogant. It was a confession. She had done this to other people, and she was proud of it. I made a mental note to find out who else had been targeted, because if I could prove a pattern of selective enforcement, I could take it to the management company and force an audit. But that was a plan for later. Right now, I needed to stop this tow. I said, I am calling the police and filing a dispute on the spot. The driver said, Look, man, I do not get paid enough to deal with this. If you two want to fight it out, I will come back later. Karen stepped forward and said, No, you will complete the tow now, or I will report you to your company for refusing a valid work order. The driver sighed, glanced at me one more time and said, I will give you 5 minutes to sort this out, then I am hooking it. He walked back to the truck and leaned against the door, scrolling on his phone. Karen pulled out another sheet of paper, this one from a stack she had clipped to a portable folding sign stand she had dragged into the middle of the driveway. I recognized the forms immediately, pre-filled violation notices with boxes already checked. She kept a stack of them ready to go, and all she had to do was fill in the date and address. It was efficient, and it was terrifying, because it meant she was prepared to escalate any situation instantly. She said, This is your second violation this month, which means the fine doubles and the tow fee is non-refundable even if you win the dispute. I am also adding a late fee for every day you delay payment. I said I have not received any violation notices this month. She smiled and said, Notices are posted in the resident portal, and it is your responsibility to check daily. Failure to check does not excuse non-compliance. I pulled out my phone and logged into the portal right there on the driveway. My notifications were empty. My violation history was empty. I turned the screen toward her and said, There is nothing here. She did not even glance at it. She said, The system updates at midnight, and if you did not check after midnight last night, you would not see the new entries. That was when I realized what she was doing. She was backdating violations and posting them after the fact, so there would be no way for me to respond in time. It was a paperwork ambush, and it was legal as long as the timestamps in the system supported her version of events. I needed proof that she was manipulating the records, but I did not have it yet. What I did have was my phone recording everything she said, and I was going to keep that recording safe because I had a feeling it would matter later. The driver walked back over and said, Time is up, I am hooking it. I said, Wait, I need to call my friend and have them move the car. Karen said, The vehicle is already in violation. Moving it now does not cancel the tow. I said, That is not how the rule works, and you know it. She said, Keep talking, I love adding notes. She typed something on her tablet, and the driver shrugged and went back to the truck. The wheel lift started whining again, and the hook slid under the rear axle with a metallic clunk. My friend came running out of my house, keys in hand, and yelled, What is happening? I said, They are towing your car even though we have a valid guest pass. My friend looked at Karen and said, I am moving it right now. Karen said, Too late, the tow is in progress, and interfering with a tow in progress is a misdemeanor under Pennsylvania law. I will call the police if you touch that vehicle. My friend froze, looked at me, and I nodded. I said, Let it happen, we will fight it later. The tow driver finished hooking the car, raised the wheel lift, and the rear tires came off the ground. Karen filmed the whole thing, narrating into her phone like she was recording evidence for court. She said, Homeowner refused to comply, guest vehicle removed per board authorization, no valid permit displayed. The truck pulled away with my friend's car dangling from the back, and Karen handed me a printed receipt with the tow yard address and a phone number. She said, You can retrieve the vehicle after paying the tow fee, the storage fee, and the HOA fine. Total is $635 as of today, and it goes up $60 per day. Have a great afternoon. She folded up her sign stand, tucked her tablet under her arm, and walked down the driveway toward the street. I stood there watching her go, my friend standing next to me in shock, and I felt a cold, sharp clarity settle over me. This was not going to end here. I was going to document everything, find every mistake she made, and I was going to take it to someone who could actually hold her accountable. That night I called my neighbor Jen, who works as a renter advocate and knows how to file complaints with housing authorities and management companies. I explained what happened, and she said, "You need to get copies of the board meeting minutes where they authorized the tow, and you need to check if the tow company is actually licensed and bonded in Pennsylvania. A lot of these predatory tow vendors operate in gray areas, and if the HOA hired an unlicensed company, the whole tow is void." I thanked her and said I would start digging the next morning. I spent the next 2 days putting together a timeline. I printed every email I had ever received from the HOA, every portal notification, every guest pass confirmation, and every payment receipt. I created a spreadsheet with dates, times, and descriptions of every interaction I had with Karen or the board. I also started taking photos of every car parked in the neighborhood, focusing on vehicles that were clearly in violation of the same guest parking rules but had never been towed or cited. I found 12 cars over a 2-day period that had no visible guest passes, expired resident decals, or were parked in fire lanes, and none of them had violation notices on their windshields. I kept my phone in my pocket, because I was saving one clip for the finale. I had recorded Karen saying that the violation system updates at midnight and that I was responsible for checking daily, which directly contradicted the HOA bylaws that required written notice via mail or email for any fine over $50. Her own statement was proof that she was bypassing the proper notice procedure, and I was going to use that recording when the time was right. But I did not want to show my hand too early, because I needed to gather more evidence first. On the 3rd day, I received a certified letter from the HOA demanding payment of $975, which included the original tow fee, 3 days of storage, the HOA fine, and a late fee for not paying within 48 hours. The letter said that if I did not pay within 10 days, the HOA would begin collections proceedings and file a lien against my property. I read the letter 3 times, checking every line for errors, and I found 2. First, the letter was signed by Karen, but it was supposed to be signed by the board president according to the bylaws. Second, the letter referenced a board meeting on a date that I knew had been canceled because I had received a cancellation notice in my email 2 weeks earlier. I called Jen and told her about the discrepancies. She said, "That is huge. If the meeting was canceled and they are claiming it happened anyway, that means they are falsifying records. You need to get a copy of the official meeting minutes from the management company, not from the HOA, because the management company is required to keep independent records." I asked her how to request that, and she said, "Send an email to the management company regional supervisor and cite the Pennsylvania Uniform Planned Community Act, which gives homeowners the right to inspect association records within 10 business days. If they refuse, you can file a complaint with the state." I sent the email that night, and I got a response the next morning from the regional supervisor, a guy named Paul, who said he would look into it and get back to me within a week. That was not fast enough, because the payment deadline was in 6 days, but it was something. I also filed a complaint with the Pennsylvania Public Utility Commission about the tow company, requesting verification of their license and bonding status. I did not expect that to move quickly either, but I wanted every possible angle covered. The next escalation came 2 days later. I was in my driveway working on a van repair when a man in a bright yellow safety vest walked up to my property line and started taking photos of my vehicles with a handheld scanner. I asked him what he was doing, and he said, "Parking compliance verification. I am with the HOA vendor." I said, "I did not get any notice about a compliance check." He said, "Notice is not required for visual inspections," and walked away. I watched him go down the street, stopping at every 4th or 5th house, scanning license plates and taking photos. He skipped most of the houses, including 2 that had cars parked halfway onto the sidewalk, and only targeted specific addresses. That night, I got an email from the HOA portal saying I had a new violation for improper vehicle storage because one of my work vans had a ladder rack that extended more than 6 inches above the roofline, which allegedly violated the architectural guidelines. I read the guidelines section, and it said nothing about ladder racks. It said that permanent structures attached to vehicles, such as camper shells or truck bed covers, had to be approved by the Design Review Committee, but ladder racks are not permanent structures. I took screenshots of the email and the guideline text and added them to my evidence file. The following week, I got another certified letter, this time saying that the HOA was scheduling a hearing for my violations, and the hearing would take place on a Tuesday at 10 in the morning. The problem was that Tuesday was the day I had a major commercial install scheduled at a hospital, a job I had been planning for 2 months, and I could not reschedule because the hospital had already coordinated with their facilities team and contractors. I called the management company and asked to move the hearing to a different date, and they said hearing dates are set by the board and cannot be changed unless the board agrees. I asked to speak to the board, and they said I had to submit a written request, which would take 5 business days to process. I was stuck. If I skipped the hearing, the board would rule against me by default, and the fines would double. If I skipped the job, I would lose $15,000 in revenue and damage my relationship with a major client. I decided to go to the job and have Jen attend the hearing as my representative, which the bylaws technically allowed as long as I submitted a written authorization. I sent the authorization letter via email and certified mail, making sure I had proof of delivery. If you are enjoying this story, hit the like button and subscribe for more wild HOA drama and real neighborhood justice. The hearing happened while I was on a scissor lift installing ductwork in a hospital mechanical room. Jen texted me updates every 20 minutes. She said the board refused to let her speak because the authorization letter had not been received, even though I had the certified mail tracking showing it was delivered 2 days earlier. The board ruled against me on all violations, added a $500 non-compliance fee, and said I had 14 days to pay or they would file a lien. Jen said Karen was at the hearing, and she presented a stack of pre-filled violation forms as evidence, the same stack I had seen on her folding sign stand. Jen took photos of the forms and sent them to me. I finished the job, drove home, and called Paul at the management company. I told him about the hearing, the refusal to accept my representative, and the backdated violation notices. He said he would review the situation and get back to me. I asked him how long that would take, and he said it depends on what he finds. I said I need an answer before the lien filing deadline, and he said I will do my best. That weekend, Jen and I met at a coffee shop and went through all the evidence I had collected. She said, "You have enough here to prove selective enforcement, improper notice, and possible falsification of records. The question is who you show it to and when. If you show it to the board, they will just deny it and escalate. If you show it to the management company, they might take action, but they might also cover for the board because it is easier. If you show it to a lawyer, you will spend $5,000 just to get started, and there is no guarantee you will win." I said, "What if I show it to the regional supervisor and make it his problem instead of mine?" She said, "That could work, but you need something big, something that forces him to act immediately." I said, "I have that." I pulled out my phone and played the recording of Karen saying that the system updates at midnight and that homeowners are responsible for checking daily. Then I showed Jen the photos I had taken of the 12 cars that were in violation but never cited. Then I showed her the meeting minutes I had received from Paul that confirmed the board meeting Karen referenced in her letter had been canceled. Jen stared at the documents and said, "This is a pattern. You can prove she is targeting you, bypassing the proper notice procedures and falsifying meeting records. If you package this right, the management company will have no choice but to suspend her access and audit the entire enforcement process." I spent the next 2 days putting together a formal complaint package. I included printed copies of every violation notice, every email, every portal screenshot, every photo of unenforced violations, the canceled meeting minutes, the recording transcript, and a cover letter summarizing the evidence and requesting an immediate management audit. I sent the package via certified mail to Paul at the management company, and I sent a copy to the HOA board president with a note saying that I expected a response within 5 business days or I would file a complaint with the Pennsylvania Attorney General's office. 3 days later, Paul called me. He said, "I have reviewed your complaint and I need to meet with you in person to go over some details." We scheduled a meeting at the management company office for the following Monday. I asked if Karen would be there, and he said no, this is a preliminary investigation meeting and board members are not present at this stage. I said good, because I have more to show you. The meeting lasted 2 hours. Paul went through every piece of evidence I brought, asked clarifying questions, took notes, and pulled up the HOA portal on his laptop to cross-reference the timestamps. He found 3 violations that had been backdated by Karen after the alleged violation date, which meant she had manually altered the system entries. He also found 2 violations that had been issued to me for vehicles that did not match any car I owned or had registered as a guest. I said, "How is that possible? He said, someone entered the wrong address or plate number, or they fabricated the entry entirely. Either way, it is a major compliance issue, and I am flagging it for the corporate legal team. Paul said he would suspend all active violations against me pending the outcome of the audit, and he would issue a temporary freeze on any lien filings. He also said he would schedule a board meeting to address the enforcement procedures and review Karen's access to the portal admin tools. I asked when that meeting would happen, and he said, within 2 weeks, and you will be invited to present your evidence directly to the board. I said, what if Karen tries to escalate before then? He said, if she contacts you or issues any new violations, document it and send it to me immediately. I will handle it. 2 days after that meeting, I got a voicemail from Karen. She said, this is Karen Clark from the HOA board. I need to speak with you immediately regarding your pending violations. Call me back at this number within 24 hours or I will escalate to collections. I did not call her back. Instead, I forwarded the voicemail to Paul and wrote, she is contacting me directly despite your freeze on enforcement actions. Please advise. Paul responded within an hour and said, I will address this with the board president today. Do not respond to her. That afternoon, a truck pulled into my driveway while I was at work. My neighbor Jen saw it and texted me a photo. The truck was from a landscaping company, and 2 workers were trimming the bushes along my property line without my permission. I drove home immediately and asked the workers what they were doing. They said the HOA hired them to perform safety trimming because overgrown vegetation was blocking the sidewalk. I looked at the bushes, which were nowhere near the sidewalk, and I said, who authorized this? They showed me a work order with Karen's signature. I called Paul and told him what was happening. He said, do not let them finish the work. I am calling the vendor now to cancel the order. I told the workers to stop, and they said they could not stop without authorization from their dispatcher. I said, your dispatcher is being called right now, so wait before you cut anything else. They shrugged and went back to their truck. 5 minutes later, they got a call, packed up their tools, and drove away. Paul called me back and said, the work order was issued by Karen without board approval, and the vendor confirmed they were told it was an emergency safety issue. I am documenting this as another unauthorized action, and it will be included in the audit report. The board meeting finally happened 2 weeks later on a Thursday evening at the community clubhouse. I arrived early with a tabbed binder containing every document I had collected, organized by date and violation type. Jen came with me as a witness. The board president, a man named Tom, was already there, along with 3 other board members and Paul from the management company. Karen arrived last, carrying her tablet and a portable folding sign stand, and when she saw me sitting at the table with my binder, she froze. Her face went pale, and she glanced at Paul, who was sitting at the head of the table with a laptop open. Tom called the meeting to order and said, we are here to review a complaint filed by a homeowner regarding parking enforcement and administrative procedures. Paul will present the findings of the management audit, and then the homeowner will have an opportunity to present his evidence. Karen interrupted and said, I object to this process. The homeowner has filed multiple frivolous complaints and has demonstrated a pattern of non-compliance. Tom said, Karen, you will have a chance to respond after the presentations. Please hold your comments until then. Paul started with the audit findings. He said the management company had identified 17 violations issued to me over a 6-month period, and of those 17, 9 had incorrect timestamps, 4 had no supporting documentation, and 2 had been issued for vehicles that did not exist. He also said that during the same 6-month period, the HOA had issued only 3 violations to all other homeowners combined, which indicated a statistically significant pattern of selective enforcement. He pulled up a chart on his laptop showing the distribution of violations across the neighborhood, and my address was highlighted in red with a spike that was 5 times higher than any other address. Karen said those violations were all legitimate, and the homeowner is using technicalities to avoid accountability. Paul said the technicalities include backdated entries, fabricated vehicle information, and improper notice procedures. These are not minor issues. They are compliance violations that expose the association to legal liability. Tom asked, what do you recommend we do? Paul said, I recommend suspending all violations issued to this homeowner, refunding any fees collected, and conducting a full review of the enforcement process. I also recommend restricting board secretary access to the portal admin tools until the review is complete. Karen stood up and said, "You cannot restrict my access. I am the board secretary and I am responsible for managing the violation system." Tom said, "Karen, sit down. We will discuss this after the presentations." Karen did not sit down. She said, "This is a witch hunt, and I will not participate in a process designed to undermine my authority." She grabbed her tablet and her folding sign stand and walked toward the door. Tom said, "If you leave this meeting, you will be considered to have resigned your position." Karen stopped, turned around, and said, "You are not the first person I have corrected, and you will not be the last." Then she walked out. The room went silent. Tom looked at Paul, then at me, and said, "Okay, let us continue." I stood up and opened my binder. I said, "I want to show you a package of photos proving multiple homeowners violate the same rule without enforcement." I laid out 12 printed photos on the table, each one showing a different vehicle parked in violation of the guest parking rules, with dates and timestamps visible in the corner. I said, "These photos were taken over a 2-day period, and none of these vehicles received violation notices or were towed." I also have a recording of Karen stating that homeowners are responsible for checking the portal daily for violations, which contradicts the bylaw's requirement for written notice. I played the recording on my phone, and the room went quiet again. Tom asked, "When was this recorded?" I said, "The same day my guest's car was towed." Tom looked at Paul and said, "Is this enough to void the violations?" Paul said, "Yes, and it is enough to support a no-contact directive and portal access restriction." Tom said, "Motion to void all violations issued to this homeowner and refund all fees collected." The motion passed unanimously. Paul said, "I will also be recommending to the corporate office that the board secretary be stripped of access to the portal admin tools and that the management company issue a written no-contact directive prohibiting direct communication between the secretary and this homeowner." Tom said, "Agreed." "Is there anything else?" I said, "Yes. I want a public memo clarifying the guest parking rules and the proper notice procedures so no other homeowner has to go through this." Tom said, "We will issue that memo within 1 week." The meeting ended, and I walked out with Jen. She said, "You did it." I said, "Not yet. I still need to make sure Karen does not come back at me." Paul caught up with us in the parking lot and said, "I am meeting with the regional supervisor tomorrow morning to finalize the no-contact directive and the access restriction. Karen will be notified by email tonight, and if she violates the directive, the management company will pursue legal action on behalf of the association." I thanked him and went home. 2 days later, I received a refund check for $1,245, which covered the tow fee, the storage fees, and the HOA fines. I also received a copy of the public memo that Tom had promised, which clarified that guest passes were valid as long as they were generated through the portal, and that all violations over $50 required written notice via certified mail. The memo also stated that the board had implemented new oversight procedures for parking enforcement, including a requirement that all violation entries be reviewed by the management company before being finalized. The final piece came a week later when Paul called me and said, "I wanted to give you an update. The corporate office completed a management audit that exposed the pattern of selective enforcement and improper documentation, and as a result, the board secretary has been stripped of access to the portal admin tools and issued a formal no-contact directive. She is no longer allowed to initiate enforcement actions, communicate directly with homeowners about violations, or attend board meetings unless specifically invited by the board president. The directive is permanent unless the board votes to lift it, which would require a 2/3 majority." I asked, "What about the other homeowners who were targeted?" Paul said, "We are reviewing all violations issued in the past year, and we will be contacting homeowners individually if we find any irregularities." I said, "Good." Paul said, "I also want to let you know that the management company is updating our training procedures for board members to prevent this kind of situation in the future." I thanked him and hung up. That night, I ran into Jen at the neighborhood mailboxes. She said, "I heard Karen got locked out of the portal." I said, "Yeah, and she got a no-contact directive too." Jen laughed and said, "Her own clip proves the opposite of her claim." I said, What do you mean? She said, you remember that video she took of the Tao? Someone posted it in the neighborhood group chat, and you can see the guest pass hanging in the windshield clear as day. She was so busy filming her victory that she accidentally recorded the evidence against herself. I said, are you serious? Jen showed me her phone, and sure enough, the video was posted with a caption that said, HOA board member abuses power and gets caught. The video had 43 comments, and every single one was calling out Karen for selective enforcement. I went home and checked the HOA portal one more time. My violation history was now empty, and there was a new announcement posted at the top of the page. It said the HOA issues a memo clarifying the rule Karen weaponized, and the memo was attached as a PDF. I downloaded it and read through it, and it was exactly what Tom had promised: clear guidelines, proper notice procedures, and a statement that the board would enforce rules evenly across all homeowners. It was not perfect, but it was progress. The next few weeks were quiet. I did not hear from Karen, and I did not see her at any board meetings or neighborhood events. Jen told me that Karen had filed a complaint with the management company claiming that the no-contact directive was retaliation, but the complaint was dismissed because the directive was based on documented violations of board procedures. Jen also said that 2 other homeowners had come forward with their own stories of being targeted by Karen, and the management company was reviewing those cases as well. I kept working, kept taking care of my business, and kept my records organized just in case. I knew that HOA conflicts do not disappear overnight, and I wanted to be ready if anything else came up. But for the first time in months, I felt like I could breathe. I had stood up to someone who thought they could weaponize the rules against me, and I had won. Not because I was smarter or louder, but because I kept receipts, stayed calm, and made sure that every decision I made was documented and legal. One afternoon, I was in my driveway working on a repair when a maintenance worker in a reflective vest walked by and gave me a thumbs up. He said, I saw what happened with the board. Good for you, man. A lot of people have been dealing with that kind of thing around here, and nobody knew how to fight it. I said, just keep records and do not let them bully you. He nodded and kept walking. It was a small moment, but it felt like validation that what I had done mattered, not just for me, but for other people in the neighborhood who were dealing with the same kind of abuse. A month later, I got a letter in the mail from the management company. It was a formal apology from the corporate office, acknowledging that the enforcement actions against me had been improper, and that the management company had failed to provide adequate oversight. The letter said that the company had implemented new training and review procedures to prevent similar situations in the future, and it offered me a 1-year credit on my HOA dues as compensation. I appreciated the gesture, but more than that, I appreciated the fact that someone at the top had taken the situation seriously and made real changes. I framed the no-contact directive and hung it on the wall in my office, not as a trophy, but as a reminder that accountability is possible if you are willing to do the work. I also kept my binder of evidence, because you never know when you might need it again. HOA conflicts can flare up at any time, and the best defense is a good paper trail. Looking back, the whole experience taught me a few things. First, do not assume that HOA board members have unlimited power. They are bound by the same rules as everyone else, and if they break those rules, there are ways to hold them accountable. Second, documentation is everything. Record conversations, save emails, take photos, and keep a timeline. If you do not have proof, you do not have a case. Third, do not fight alone. Find allies, whether it is a neighbor, a lawyer, or a management company rep who is willing to listen. Fourth, stay calm and do not give them a reason to escalate. The more emotional you get, the easier it is for them to paint you as the problem. And finally, do not give up. It is easy to feel powerless when you are up against a board that controls the rules, the money, and the enforcement process. But the system is not designed to protect bullies. It is designed to protect homeowners, and if you know how to work the system, you can win. I still live in the same neighborhood, and I still deal with the same HOA, but things are different now. The board is more careful, the management company is more responsive, and the enforcement process is more transparent. Karen is still on the board technically, but she has no real power anymore. She cannot issue violations, she cannot contact homeowners directly, and she cannot attend meetings without permission. The other board members know what happened, and they are not going to let her pull the same tricks again. Every now and then I see her at the mailboxes or the clubhouse, and she pretends I do not exist. I am fine with that. I do not need her approval, and I do not need her to acknowledge what she did. I just need her to stay out of my way, and thanks to the no contact directive, she has no choice. Thanks for watching, and I am glad you stuck around.